My name is Angie Hayden Sutton with Save Our School, Elmhurst High School, and I'm here today with our legal counsel, Robert Vegeler of Vegeler Law Office, LLC, and we're here to get a few questions answered for our supporters. And first of all, I would like to ask Mr. Vegeler, what is the present status of the litigation and what is the next stage?
Okay. Answer the first question is suit was filed on behalf of Save Our School, Elmhurst High School, in Allen Superior Court on April 20th, shortly before noon. And that suit is a verified complaint for declaratory judgment and judicial review. Now, what that means is that's two separate counts or causes of action. Declaratory judgment is a special type of lawsuit that is supposed to be on an expedited time frame so that the parties can have their legal question answered. It's a legal question and the court answers the legal question. And in this case, the legal question is whether or not the closing of Elmhurst High School decision by the Fort Wayne Community School Board of Trustees was an unconstitutional act violating Article 8, Section 1 of the Indiana Constitution, which requires there be a common and uniform system of schools. And Save Our School has, based upon the facts in the complaint, believes that the transfer of Elmhurst, almost 900 Elmhurst students to underperforming schools, high schools, Northside, Southside, and Wayne, violates the uniform part of the Constitution because it is Save Our School's belief that those schools are performing materially worse than Elmhurst is. The second part is the judicial review, which is an administrative proceeding. A final administrative proceeding was done by the school board, and that can be reviewed by a court to see if it was arbitrary, unlawful, illogical, perhaps, to the point where it's not even supported by the evidence on the record. So that's a special kind of judicial proceeding. So that is where we at, where the status of the litigation is today. There will be a motion to expedite proceedings filed with the court today, this being Friday. There will be a motion to vacate the case management conference and move it forward so the court can start this case earlier. And discovery requests such as interrogatories, requests for production, depositions even are effectively being worked on right now so that they can be conveyed to the counsel for the defendants. Now that's where we're at today.
All right. Now, can you give me a brief summary of what your legal theories are and what facts are in the complaint to support those theories?
Okay. Save Our School, and in close working with you, we decided that the real two most viable and supported by the facts legal theories was one, violation of Indiana Constitution Educational Clause, which I've kind of explained, and judicial review of the Board of Trustees decision. Now, the facts were specifically attached to the complaint as exhibits. In fact, this is about 90 pages of exhibits. And Save Our School, through your help and our thinking, we decided that we wanted everybody to know exactly where Save Our School was coming from as far as the facts go. These facts, everything that is in this complaint is in these exhibits, and it's a matter of public record. And so anybody who gets a copy of this complaint and these exhibits can verify that anything that is said in this complaint is in this exhibit as a matter of public record. Therefore, nobody can say that Save Our School hasn't been upfront and transparent as far as saying this is what the facts are. And some of these facts are complicated, some of them aren't. There is Indiana constitutional debate theory, debates in here from the 1850 Constitutional Convention showing why a uniform school system in the 1816 Constitution wasn't good enough because of illiteracy and underperforming schools, so they made it uniform, common, and uniform so that the schools got better. And there are financial records in here, there are test results, there are student performance by high school, there's Fort Wayne Community School performance records in here, there's budget records, there's the class descriptions from Fort Wayne Community School's own publication, and the decision matrix that the board used are all in here. Now that's an outline of the facts, and quite simply, the theory can be summarized as the fact that according to the published records from the Indiana Department of Education for 2008 performance, Fort Wayne Community Schools rating put it in 17th from the bottom as far as performance as set forth in that public record out of 294 school systems. And Northside and Southside have been on 4 straight years of academic probation. And the graduation rate at Elmhurst is higher than Wayne High School. The advanced placement courses and college courses available at Elmhurst, according to Fort Wayne Community Schools' own publication for next year, strongly is 3 to 4 times greater than at Wayne High School. And that there has been no capital expenditure records that we have seen that supposedly is going to have to be paid for at Elmhurst that's in the public record that we have seen. So we're trying to get that. And the fact is that we do not know why a $337 million institution, Fort Wayne Community Schools, can't find $1.6 million to keep Elmhurst open. Those are some of the facts. Those are some of the hot button points, and so forth. There's 2 laws. There's a federal law, No Child Left Behind, in which the superintendent of public instruction of the state of Indiana just announced in the newspaper this morning that since supposedly because they're not getting cooperation from the teachers union, they are not going to even apply for more money. They're turning down millions of dollars and not even applying for it. That's a separate issue, not involved in this lawsuit. But more importantly, Public Law 221, which is the I-STEP, basically works off the I-STEP tests, indicates that when a school is past its 4th year of academic probation, that the superintendent of public instruction in the Indiana Indiana Department of Education can literally take over schools and get rid of all the administrators, get over teachers, and start over and try to make that school a performing school. I'm not saying that we have any information that's going to happen here at Northside or Southside, but that's what's in Public Law 221, and that's something we don't want to have happen involving the students that are at Elmhurst. We don't want them to have to go to a school that is maybe 1 year away from being taken over by the state of Indiana.
All right, Mr. Vegeler, at this point, have you received any response from Fort Wayne Community Schools in regards to the litigation?
No response as to legal proceedings. Obviously, there have been some comments in the press from president of the school board and a anonymous member of the school board, and don't know why they felt they had to be anonymous, even though they voted openly against keeping Elmhurst open. But I suspect we'll be getting a rather strong response consistently from now on, a barrage of legal and other comments.
All right, well, we thank you for your comments and this information, and we'd like to direct everyone to our website, www.sosehs.com, to actually view an electronic version of our legal complaint and the exhibits that have been discussed in this question and answer session. Thank you.
Thank you.